Why is it critical for a trial attorney to anticipate the legal issues that are going to arise during trial and to have a trial brief prepared ready for the judge during trial? You want to know why? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now, in every single one of these civil lawsuits involving medical malpractice, accident cases, wrongful death cases, there will always be legal issues that arise. Maybe it's a piece of evidence that we want to introduce at trial, and we know the defense is going to give us a hard time. Maybe the defense wants to get out information about something that happened in your past that you don't want to get out in front of the jury. And now you can't simply wing it off the cuff and make a legal argument. What do you have to do instead? An attorney has to prepare what's known as a legal brief. And a legal brief is a compilation, a collection of cases that are similar, that are on point, that have similar fact patterns to yours. And now we can turn to the judge and say, Judge, in this case, a judge in this state determined that based upon this set of facts, he ruled this way in favor of the injured victim. And that's exactly the situation we have here. And that's why you must rule in our favor. The defense will have an opportunity to oppose that and present their own legal cases showing why the judge should not rule in our favor. But a really smart attorney must anticipate all of the legal issues, the significant legal issues that are going to arise during the course of trial. Because what will happen is if we try and introduce something into evidence and the defense yells, "Objection, Judge, that's improper." And now the judge turns to us and says, "Mr. Oginski, what legal basis do you have for making and introducing this information?" And now if I don't have anything prepared, I'm now trying to wing it, and the judge is going to make an off-the-cuff ruling simply denying my request. Why? Because I didn't prepare legal precedent to show to the judge, Judge, here's a series of 10 cases that ruled in our favor in a similar situation. And now the judge can actually look at it, analyze it, interpret it, and then make an educated decision about whether or not those prior cases are similar to our particular case, and if so, then rule in our favor. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in every single civil lawsuit trial that goes on here in the state of New York. Yet I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you've got questions about your particular matter, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.